we have returned. All right, so let me throw something else out you in reference to this argument of First Amendment, Second Amendment. We can limit and couch the Second Amendment in a different concept or terms than the First Amendment. If you want to compare the two, they're screaming about assault weapons. And yet, with all due respect, you could currently call television an assault weapon, a high-capacity assault weapon in the hands of the Ministry of Propaganda. The mainstream media espouses anything that furtherances their positioning, but denounces you for wanting to have the ultimate means to defend your nation. Free speech in every form, just like firearms, were left to the unrestrained use and the possession of the people, specifically to thwart tyranny in government. That was the entire premise. It had nothing to do with anything else. Limiting one always ends up with the undesirable consequence that government can act in a manner that is against the best interests of the people, whom were its initial creator. George Washington gave us a phrase which we would all do well to remember. In fact, carry it around on a little card in your wallet if you need to. Government is not reason. It is not eloquent. It is force. Like fire, it is a dangerous servant and a fearful master. Our nation was formed and built on a healthy distrust of government, because like all governments prior, historically, this government itself has shown that it will always lead towards usurpation. No one can deny that. Left to its own devices, it is dangerous to liberty and freedom. Over time, given the amassing of unchecked power in all aspects, in all three branches, the legislative, the executive, and the judicial, it is inevitable that all governments become tyrannical, including this one. Allowing the Second Amendment to be infringed has been a series of giant steps in that direction. The purpose of the 10th Amendment was to delineate those powers that weren't expressly delegated to the federal government and reserve those to the states, and then those that weren't reserved to the states were actually given to the people for the principles of self-governance. Right? It allows the state to act as a watchdog over government, the federal government, because they are the actual creators of the government itself, the various 13 states at the time. As the creators, they envisioned a federal government that could clearly grow beyond their control, like fire, a dangerous servant, and a potentially fearful master. The national government is a creation of the states, and therefore it can no more be a master of those states than the slave can dictate the rules to its owner. Your dog can't dictate the rules to you. You're the master. It's that simple. In Mr. Nixon's argument, including the self-serving citations of court cases where he outlined the supremacy clause, he's dignified it with an unqualified and conflicted judiciary with powers that they don't actually possess. And we should be clear about a couple of issues. One, the founders' expectations for the role of the judiciary were diametrically opposed to the principle that the courts are the final arbiters of disagreements or conflicts between the states and the federal government itself. They understood that the courts could impartially judge a conflict in a dispute between two different states, i.e., Massachusetts and Connecticut. That action was the true intent of the Supreme Court. But they were also equally clear that there was a conflict of interest that was inherent in the idea and in the concept when it came to a dispute between the federal government and the states themselves. Because the idea is that if the Supreme Court is the final arbiter, and the Supreme Court is in fact a segment of the federal government, it owes its allegiance to whom? The federal government, and therefore is not an impartial arbiter. Jefferson himself in 1825 said the following: "It is but too evident that the three ruling branches of the federal government are in combination to strip their colleagues, the state authorities, of the powers reserved to them, and to exercise themselves all functions, foreign and domestic." Now, I want to read that to you again because it's very important. It is, remember, this was done, he made this statement in 1825 when they'd had, at this point in time, some 60 some odd years of actual, or 35 if you want to count from ratification, of actual opportunity to observe how the federal government was moving and migrating and growing and expanding, right? So this wasn't said as a warning. This was sent as an observation. It is but too evident that the three ruling branches of the federal government are in combination to strip their colleagues, the state authorities, of the powers reserved to them, and to exercise themselves all functions, foreign and domestic. He's warning us and telling us this is already happening. Alexander Hamilton added to that, "No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid." If you take into account that the argument that the Supreme Court or any lesser federal judiciary should have the right to arbitrate a dispute between, the states and the federal government, you're mistaken. Because as part and parcel of the federal government, it is an unconscionable conflict of interest. And that, ladies and gentlemen, is where the problem resides. Spencer Roane, he was narrowly missed as an appointment for Chief Justice, and he summed it up very well. Here's what he said, and this is an important statement. Quote, "It has, however, been surmised by some that the right of the state governments to protest against or to resist encroachments on their authority is taken away and transferred to the federal judiciary, whose power extends to all cases arising under the Constitution. That the Supreme Court is the umpire to decide between the states on one side and the United States on the other, in all questions touching the constitutionality of laws or acts of the executive. There are many cases which can never be brought before that tribunal, and I do humbly conceive that the states never could have committed an act of such egregious folly as to agree that their umpire should be altogether appointed and paid by the other party. The Supreme Court may be a perfectly impartial tribunal to decide between two states, but cannot be considered in that point of view when the contest lies between the United States and one of its members. They cannot do it unless we tread underfoot the principle which forbids a party to decide its own cause." Wow. I mean, guys, this isn't some kind of conspiracy thinking here. You can see time and time and time again where these people who were one, heavily involved in the actual creation of the Constitution itself, and were judicial and educated scholars of the Constitution, and were involved in watching the Constitution begin to be eroded almost immediately, were calling out saying, this is already happening, and these are problems. Joseph Dacia, he was the governor of Kentucky in 1825, and here's something he said. Sorry, but I'm taking a drink of coffee there. In 1825, he made Nixon's folly clear. Governor Nixon's folly clear. Quote, "In fact, most of the encroachments made by the general government flow through the Supreme Court itself, the very tribunal which claims to be the final arbiter of all such disputes. What chance for justice have the states when the usurpers of their rights are made their judges, just as much as individuals when judged by their oppressors?" He went on to state that he believed, quote, he went on to quote, "It is believed to be the right, as it may hereafter become the duty of the state governments, to protect themselves from encroachments and their citizens from oppression by refusing obedience to unconstitutional mandates." Boom. Contrary to the arguments out there by the progressive left, we don't have to look very far to see the subjective application of the principles of state nullification, because we look at it and we can see it everywhere. And it's amazing how they apply it and want to agree with it only when it benefits their position. Look at Colorado. Look at California. Look at Washington, where they've nullified federal marijuana law. You can't demonize nullification on one hand and claim it to be your salvation on the other. You can't hide the ironic hypocrisy of using it when it only suits your agenda. I would also remind our listeners that the northern states were the ones who used nullification laws to fight back against slavery and the highly unpopular Fugitive Slave Act in the 1850s. President Obama himself is using it, as you read this, to defy federal law related to immigration and deportation of his unconstitutional implementation of the DREAM Act. In other words, the federal government and the president himself are nullifying federal law based on a dictatorial edict as opposed to a state defending itself from a federal government and tyranny. We know that because the president's also doing it under Obamacare. How did he do it under Obamacare? Well, first of all, he gave Congress their own special dispensation from it. And secondarily, he's violated the law by saying he's going to individually, unilaterally, and personally declare certain segments of the law not to be enforced until such time as he gets around to declaring it's okay to do so. In other words, putting off a year the fact that companies don't have to apply, while individuals do. The argument that you'll hear from the left all the time is that nullification was settled by the Civil War. They'll always say, that was settled back in 1865 by the Civil War. The Supremacy Clause overrides states. That is an intellectually dishonest and poorly presented argument. Nullification is currently practiced right now, and we see examples of it every single day, by the same administration that declares its use invalidated when it doesn't meet their agenda. How can we accept the threat of Eric Holder, who arguably failed to adhere to the law that he demands others observe, when he told Kansas, who passed the Second Amendment Preservation Act, that its nullification of all federal gun laws is both illegal, unconstitutional, and authorized? So, explain to me, Mr. Holder, how it is that you can sit there and have the unmitigated gall to say to us what Kansas has done in its interposition ruling is unconstitutional, but it's not unconstitutional for California, Colorado, and Washington State to defy marijuana law. And it's not unconstitutional for you and the president to declare unilaterally and dictatorially, I might add, that immigration laws must not be enforced. Remember, the only function of a president is to faithfully execute the laws of the United States. That's it, folks. Kansas Governor Sam Brownback was clear, and he wrote a great response, and along with Chris Kobach, Kobach, the Secretary of State for Kansas. Let me read it to you. The right to keep and bear arms is a right that Kansans hold dear. It is a right enshrined not only in the Second Amendment to the United States Constitution, but also protected by the Kansas Bill of Rights. The people of Kansas have repeatedly and overwhelmingly reaffirmed their commitment to protecting this fundamental right. The people of Kansas are likewise committed to defending the sovereignty of the state of Kansas, as guaranteed in the 9th and 10th Amendments to the United States Constitution. Chris Kobach, the Kansas Secretary of State, went on to add, it was drafted with the intent to assert Kansas's authority as a co-equal sovereign under the United States Constitution to regulate a matter that is outside Congress's jurisdiction. When the government of the United States, the national government, acts as the oppressor by way of laws, rules, and regulations and other infringements on either our individual rights or our states' rights, it is the duty and the obligation of states and individuals, I might add, and their legislatures to protect that citizenry by interposing themselves between the bully and the victim. Over the past 100 years, we have seen the Supreme Court and numerous inferior courts whittle away at the liberties of states and people with self-serving decisions on issues that range from Commerce Clause abuse to the General Welfare Clause interpretations that virtually no one who is intellectually honest or constitutionally learned can approve of. We have to keep in mind that the usurper always believes he acts with justified authority, right? In other words, they believe they're acting with justified authority, or at least they're claiming to. John Adams made it very clear when he said, power always sincerely, conscientiously believes itself right. Power always thinks it has a great soul and vast views, beyond the comprehension of the weak. Now that's a scary statement, because what it does is it defines for you the hubris and the arrogance of those who are in the power class, the ruling class of the elitists in government. But then he came around and gave us the answer to that. He says, we must nip the shoots of arbitrary power in the bud, as it is the only maxim which can ever preserve the liberties of any people. The Supreme Court, and for that matter the legislature and the executive, have no more power to pass or affirm laws that violate the Constitution than they have power to unilaterally declare a dictatorship. The judiciary, the court system, while partially intended to act as a check against legislative and executive power running amok, is not excused from the checks of states' nullification rights and declarations, because its conflicted decision sides with the executive or the legislative. Let me be perfectly clear here. Governments have no authority to infringe the people's right to acquire or possess firearms or any ancillary accoutrements that would be necessary to make those items function, including ammunition, by the way, regardless of any claimed justification, whether it's federal or state. Using the argument and the risk of public injury and death by a truly minuscule percentage, I mean almost infinitesimal, is unethical, it's dishonest, and it's subjectively applied where guns are the topic. Always. Even when some would quote that the numbers of death and injuries substantiate their usurpation of individual rights, we can't escape the hypocrisy of limiting guns and firearms while we don't limit automobiles and swimming pools and bicycles and baseball bats and golf clubs and the myriad of other items which can be used to injure or take a life. If you base it on that argument, in order to prevent unauthorized or unintended police shootings, we should disarm peace officers. No one would argue for that. What's important is that ultimately we have to recognize that the principle of nullification and interposition on the part of states is the final interim remedy short of secession. because secession would actually destroy the Union itself. The goal of a state that employs nullification is to act as an intermediary, as a separator, and defend and protect its citizens from acts which would otherwise force that state to leave the Union to protect itself and its citizens. So as an interim final step before the ultimate step of separation, the state must say, we declare these unconstitutional mandates to be null and void. This infant nation was assured by the founders that a federal government would possess only those powers expressly granted to it by the states. The fact that the word expressly does not appear in the 10th Amendment does not mean the states get anything less. James Wilson at the Pennsylvania Convention, he stated very clearly, quote, everything not expressly mentioned will be presumed to be purposely omitted. Governor Johnson, Samuel Johnson, when he was at the North Carolina Convention trying to get this ratified, said, Congress cannot assume any other powers than those expressly given them without the palpable violation of the Constitution. The powers of Congress are all circumscribed, defined, and clearly laid down. So far they may go, but no further. Madison said it in Federalist 40. Here's what he said. Quote, the general powers are limited, and the states, in all unenumerated cases, are left in enjoyment of their sovereign and independent jurisdiction. He also said in Federalist number 45, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. No amount of legalistic wrangling, verbicide, or rationalization can change the fact that states are left in control of all the non-enumerated powers that were never specifically delegated to the federal government. Because the federal government has actually taken this limited power of authority or power of attorney that we've given to them and misused it in its intent and in its design, does not give them license to continue to expand upon those things which they've done, which are actually wrong, but not pointed out or corrected. John Adams said, but a constitution of government, once changed from freedom, can never be restored. Liberty, once lost, is lost forever. The reason that the Missouri legislature should override Governor Nixon's veto today is very simple. For them to do less would be an abdication of the authority of the states under the 10th Amendment. And it would place them in a role of malfeasance of their fiduciary responsibility to the citizens of the state of Missouri, as their role is required to be the protector of the people. Let me be perfectly clear about this. Any senator, any state representative who fails to follow their original vote and turns tail on this issue must be immediately removed from office. I'm not asking you. I'm telling you that the only way that we can declare our state sovereign is by we the people making sure that our legislatures and our elected representatives are following our will. It is our government. It is not theirs. We are not their servants. We are their masters. Okay, we're going to break. When we come back, we're going to talk about, I tell you what, I'm going to jump straight to this Obama thing because I know it's going to take me 2 segments to get through it. There's a lot to go over here. This was the speech last night on Syria, and it's a damning thing. please make sure that you find us on the web. You can find us by going to americasvoicenow.org. You can find us on Facebook at facebook.com/America's Voice Now. And you can find this and every other program that we do. We record them all, stream them live, and then we put them up on YouTube where you can find them, share them, and learn from them. If you don't agree with me, that's fine. Post a comment up. We'll discuss it. Or you can give a call into the show. We want to hear from you. We'll be right back.